There's nothing in the Constitution anywhere that dictates that the federal government shall give federal taxpayer money to the states.
Yeah, well, we
know.
thought the same thing, though, when it came to USAID, to be fair, Valiant, okay? There was nothing that said we had to honor our contracts and promises for financial reimbursement on some of these contracts, especially overseas. That is squarely within the right of Congress and the right of the United States to renege on our own contracts and say, we're not paying. That's our right. And that wasn't even examined today.
Renegade Online.
And if you really want to see numbers, just take a look at what happened in the women's boxing, weightlifting, track and field, swimming, or cycling, where a male recently finished a long-distance race 5 hours and 14 minutes ahead of a woman for a new record by 5 hours. Broke the record by 5 hours. It's demeaning for women, and it's very bad for our country. Put up with it any longer.
Let me ask you guys from the legal standpoint, because this keeps coming up. What is, or how much of a fight is this going to be? I mean, I know we have things like Title IX on the books, and it's there for obvious reasons. It's there for women's athletics. It's there for women's sports and so on and so forth, right? If that's the one I'm thinking of. It seems like the law's already there. And how easy is it going to be for Trump to actually be able to follow through with this on his own as just an executive device to stop federal funding for schools that don't play ball? No pun intended with this.
The answer is, and the reason I know anything about this at all is because Jane Coleman, my wife, explained it to me. There was never any government change here. There was something called a Dear Colleague letter that went out under Obama, and which suggested that here's what you need to do from now on. And the schools, and I don't think they had to be dragged kicking and screaming over this, took this as a signal to start this trend toward letting transsexuals be on the team that they claim that they wanted, that they should be. That Dear Colleague letter was already withdrawn. So it's not so clear how much of this really is amenable to being fixed merely by executive order.
Yeah. Every move that Trump has made in the last 5-6 weeks since he's back in office has been met with, and I would say probably in many cases, perhaps if not every case, has been met with a restraining order from a lone federal judge saying, nope, can't do that. Or no, we have to wait. And to me, it seems like every time he tries to do something, whether the judge may have any legal standing to stop it or not, I don't know. I'm not the expert, but it seems like maybe just the game is to delay him as much as they possibly can. Just to try to keep throwing as many wrenches in the machine as possible, even if they know it may not in the long term be successful.
That might be true, but on the other hand, it's not insane for them to think that maybe they went in court because, look what happened today. It's true that today's ruling was not a substantive ruling on the merits. But when you've got people like Roberts and who am I thinking of?
Barrett.
Oh, Amy Coney Barrett.
Right, Barrett?
Yeah.
Who are so hung up on threading the needle that every appeal has to be precision. And even though, as Alito pointed out, here's a court that doesn't even have jurisdiction over this question. But they've got this obsession, this fetish with going through precisely the groove that they think is appropriate. Who knows? Who knows what they could achieve? Maybe no one's going to read the tea leaves for until one of these judges dies. He's going to be within 4 years. I don't know. Could it be 2 years? And perhaps the Senate. it's an entirely rational tactic when you've got such, feckless Supreme Court justices.
Danny,
Also,
thoughts? Mhm.
yeah, there was a huge push during the Obama administration to start enshrining in each state's constitution protection of gender identity from a state level. And so what these states were doing is they were saying, okay, well, it's in our constitution already. We'll attach that to Title IX with our schools, and then we'll get federal funding and also include transgender people as part of this Title IX protection, although that was never what was intended at all by Title IX. So it is interesting. There's a two-pronged approach. And this is a common approach, whether it be victims' rights advocacy, whether it be pro-life advocacy, is to go from state to state. If you're not getting what you want from a federal level, even if you are getting what you want from a federal level, you know that that's not going to last forever. Just like with this colleague letter, that that's not going to stay. There's no staying power there. These presidential orders don't have much staying power. So if you can get it implemented in each state, and then you can hook those federal funding to state laws and say, well, you already agreed to give us this funding, and now if you back out because we've changed the state law to protect an additional group of people, you're violating your promise to the state. We've already put up our half. You need to put up the other half. And so it creates this two-way approach of litigation to ensure that they keep getting funding. But I mean, from a federal level, there's no question that this does not extend to allow biological men into women's sports at all.
You wouldn't think so, yeah.
State level, though, that's where it starts getting really messy. And that's where a lot of these cases have come up and bubbled up from states like Minnesota. I know that Utah was trying to extend it, our protections under the Constitution, our state constitution, that failed. But we still have other policies, other state laws that do extend those protections. So
it'll be interesting to see with stuff like this, I think, Danny and Ron, going forward, to where it's like you said, okay, we made a promise based on last year's budget. This is what we said. They have to fight it out in court, I guess, if the federal government rescinds it. But then going forward, hey, look, this is the new rule. So this is how it's going to play. And it might not work in 2025 because you've already theoretically got a budget set for this year. But 2026 might be a different story. And let me, Law School 101, I'm going to ask a question I already know the answer to, right? And that is there anything in the Constitution that grants individual states the rights to the gifts of the federal treasury?
No.
Thank you. Yeah. So no, it doesn't. So this has kind of always been my argument over the years with people, is that, look, there's nothing in the Constitution anywhere that dictates that the federal government shall give federal taxpayer money to the states.
yeah, well,
so
we thought the same thing, though, when it came to USAID, to be fair, Valiant. Okay. There was nothing that said we had to honor our contracts and promises for financial reimbursement on some of these contracts, especially overseas. That is squarely within the right of Congress and the right of the United States to renege on our own contracts and say we're not paying. That's our right. And that wasn't even examined today with today's decision. So I'm really concerned with where things are going. Hopefully the judiciary gets its act together.
Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.